Buddy, this is Bobby here, attorney Bobby Buchanan. It is noon on Tuesday, March 19th. Thanks for joining me. This is a pretty informal webinar about the uncontested divorce process. Basically, what I like to do in this webinar is help people understand how to get divorced without it turning into a 12-round fight or even a 1-round fight. There is a much better way to do divorce. Sometimes it is necessary to go to court, and as divorce attorneys, we are ready to go fight for our clients if we need to. But it's definitely more fulfilling for me and my clients if we can get through this process without it turning into an emotional and financial battle. It's better for the family if you can make it through without that sort of stress. So let's dive in. What you're going to discover in this webinar is that divorce can be easy. You can protect your kids. You can protect your assets. You can avoid your spouse's debts, and divorce can be fast. The biggest advantage to doing it the diplomatic way is really that there's much less stress and there's much less expense to it, and it is faster. So let's talk about it and talk about why this might make sense for you. If you're frustrated with all the misinformation and the confusing stuff that surrounds the divorce process out there, you've Googled in circles and you just end up not really knowing what's what. It's kind of like Googling a symptom. You end up thinking, well, is this just going to go away or do I have cancer? And it's really hard to assess what is actually going on in the divorce world. You're wanting to move on to the next chapter of your life fast, and you're worried about it being dragged out and expensive. You're worried about your kids in the process, and you're wanting to protect your assets and know the best way to handle real estate, retirement accounts, and vehicles, etc. So with that being said, let's talk about first, who am I? I'm a husband. I'm a father of two. I come from working class parents. I was actually the first to go to college in my family. And the way that I got here was I was searching for meaning in my life, and I started being a courtroom lawyer, and I got disenchanted with that. I got disenchanted with helping people through the divorce process in the courtroom and how much fighting there was, and how it seemed like attorneys were just butting heads and it wasn't helping clients get to the other side. So that's when I said to myself, you know what? I'm going to build a firm because I enjoy being a collaborator. I enjoy being a mediator. I want to help my attorneys and help my clients do this in the best way possible. Now, certainly, we still go to court. We still have to go through the court process sometimes. We still go to battle. We get great victories in court. We help people through stressful processes. But we try to help our clients avoid that as much as possible as well. I am also a tech nerd, so there's a lot of automation associated with my firm. And our office at this point, and I am 100% owner, we have 7 total attorneys, 4 paralegals, and all we do is family law. So this is my bread and butter. So let's talk about how you can move on to the next chapter of your life, protect your kids, protect your assets without spending thousands and thousands on attorney's fees. Now, listen, the perfect process for you is going to depend on what's most important to you. Getting to the next chapter as soon as possible, maximizing what you get in the process, or maybe there is a middle ground there. So let's talk about the overview of the actual divorce process. You can get to the finish line in a lot of different ways, but the finish line is always the same. For a divorce, the finish line is one or two things if you have kids. The first thing that everybody is going to have in their divorce to end it is a marital settlement agreement. I say with a slight caveat, and that is if you are one of the very few people that ends your case with a trial. And, I don't know the specific statistic on it, but it's probably less than 1% of all cases go through an actual trial. A fair amount of cases look like they're going to trial, but then they settle right before trial. So for all intents and purposes, everybody finishes their divorce with a marital settlement agreement. That's signed by you, that's signed by your spouse. That's basically the contract that outlines what's going to happen with your property, your debts, any support issues, alimony, child support, that sort of thing. And then there is the thing that everyone has who has kids that goes through divorce, and that's your allocation judgment, also referred to as a parenting plan. So that's going to outline the schedule and the decision making. And I'm going to go over these things a little bit slower. And I know I'm talking fast, and that's because it's the middle of the day. You might be on your lunch break. And so I want to make sure that we can hit as much of this stuff as possible. So how do you get there? How do you get to this finish line? Well, you either get there by cooperating with your spouse, or you get there by using the court process, or sometimes a little bit of both. So the key to getting there, to get to the marital settlement agreement, the key to getting there in the most uncontested way is going to be through cooperation. So that's really what we want to keep in mind. The high level takeaway here is the more that you can cooperate, the higher chance you have of having an uncontested divorce. And I'm going to talk a little bit later about things that you should and shouldn't do if you are serious about getting an uncontested divorce. But first, let's give you a good understanding of that final document that you need and what's actually in there. The marital settlement agreement. It's going to resolve all property and support issues. And before I continue here, let me just throw this out there. This is a relatively small webinar as far as our group here. And I'm going to turn chat on to private so only I can see it. And I invite you, as we go through this process, if you have questions, just to put them in the chat, and I'll incorporate them into my lecture, my webinar here. So this is really an interactive webinar if you want it to be. I'm not going to divulge anyone's name here. I'm not going to divulge any details that would get let's say there's a slim chance that you and your spouse are both on this webinar. I'm not going to divulge any details that would expose that situation. So with that being said, let's go through the marital settlement agreement. It's going to resolve all the property and support issues. It's going to be based most likely on some sort of financial disclosure. There has to be some level of transparency in all divorces. It's very rare that you do a divorce and there's not some level of financial disclosures. And it's problematic if there is not some level of financial disclosures. It can be really detailed, and that's generally recommended. Or it could be general, not recommended. So, for example, detailed. If you're talking about real estate, well, who's keeping the house? How much equity is in there? How are you going to split up the equity? Is there going to be a cash out refi? What happens if the other side can't refi? How are you going to sell the property? How are you going to pick a real estate agent? How are you going to decide on which offer to accept? All of these questions are questions that we're going to want to address in an uncontested divorce to make sure that things don't get contested down the road, that we're all on the same page, and that our agreement is a rock solid agreement. So the sections in a marital settlement agreement, what are they? Well, we're going to talk about real estate, bank accounts, investment accounts, retirement accounts, businesses, debts, tax issues, personal property, how we're going to equalize the estate. Maybe I'm giving $30,000 to my spouse, or $3 million, or 30. Then we're going to talk about maintenance and child support. It doesn't mean there has to be maintenance or alimony. It just means that we need to address it in the settlement agreement. We might be waiving it for both sides. Both sides might be saying, I don't want maintenance. I don't want maintenance. So just keep that in mind. I'm going to run through some scenarios with you to kind of give you some ideas and options for how we deal with things as divorce attorneys in this process. I'm not going to say this is the end all be all. This is kind of your divorce 101 here. So I made up two names, Eric and Tina. So let's pretend that Eric and Tina have a Downers Grove house worth $740,000. Tina and Eric are on the deed, but just Eric is on the mortgage. I just saw a question come through, so I'll get to that as soon as I can. So option one, Tina and Eric are on the deed. They're both on the deed, just Eric on the mortgage. What has to happen? Well, Eric keeps the house and buys Tina out. So this could be done with a cash out refi or other asset offset. For example, maybe retirement accounts. And they need to agree on the equity or use an appraiser. And then the property is going to be quit claim to Eric. A little simpler here because Eric is on the mortgage. Option two is Tina keeps house and buys out Eric. The difference here is that Tina is going to need to refi and prove to a bank that she is a good investment to get on that mortgage in order to get Eric off that mortgage. That can sometimes be difficult. And then option three is to sell the house and split the proceeds. All right, the first question, let's tackle it here. Let me just read it so that I am not, being too detailed. So this first question talks about, is there alternatives to a buyout? Let's say that I'm the husband and I agree with my wife that my wife is going to stay in the house. But we don't want to do a buyout for whatever reason. The biggest reason that we insist on a buyout for our clients is because if your name stays on the mortgage, because it really comes down to the mortgage and the loan. If my wife is staying in the house and I'm trying to move on to the next chapter of my life and I want to go buy another piece of property, I have to have pretty significant income in order to get another mortgage, because the bank is going to look at the other mortgage, the first mortgage, and say, hey, you don't have the income to support two mortgages. So if you do have the income to support two mortgages, then this is a non-issue and you can get more creative. So that's really the principal reason that we look at getting someone off of a mortgage. If you're not concerned about getting off of a mortgage, there is no rules against you continuing to have joint tenancy with your spouse beyond the divorce. Absolutely, you can do that. We're going to tell you, it's not a good idea because X, Y, and Z. And generally speaking, keeping assets intertwined after a divorce has a tendency to complicate things. But that's up to you. If you want to do that, we'll let you know what your exposure is, the risks that we see. And then you say, you know what, Bobby, I still want to do that. And we'll say, okay, great. We're going to craft this agreement so that it protects you as much as possible. Next question is pretty general and pretty common question. What if your name isn't on anything and you've been married for 9 years? Well, then we look at, is this property marital property? And for example, a house that is purchased 2 years into the marriage, but just has the wife's name on it, is generally marital property because it was purchased during the marriage. Now, if it was purchased with an inheritance that your wife got, then there's going to be a calculation to see, well, is any of the equity marital? Should there be a reimbursement to her for the down payment and questions like that? But generally speaking, anything purchased during the marriage is going to be considered marital property. I can't remember if I went over it, but option 3 is going to be sell house and split the proceeds. This can be the most straightforward option. Can be a little bit difficult if there's already been a separation and there has to be full cooperation from both sides, and including the person living in the house. The areas where we see this go south the most is where someone's living in the house who doesn't want the house to be sold, and they can really throw a wrench in the works and drag out the process and make it very difficult. So that's something to consider if you are going to sell the house. What if it's joint property, but I made all the payments, mortgage, tax, etc.? That's not going to carry as much weight or any weight usually. That's not what the law is in Illinois. The law in Illinois, judges routinely say that an equitable split of the equity is going to be 50-50 regardless of who is actually paying for it. Now, the devil is in the details, and whether or not we might be able to negotiate a 60-40 split or a 70-30 split is something that we can examine as we start the process. But I would not set your expectations there. I would set your expectations on the fact that it's going to be a 50-50 split, even though you broke your back, you pay for everything, and your spouse just, was on their Barca lounger the whole time and didn't contribute in the same way that you did. Unfortunately, the law is what it is, and there's not a whole lot we can do about it. But sometimes there are exceptions here, and we are more than happy to make a case for you in court. But I wouldn't bank on getting an uncontested divorce if you're not going to split that equity 50-50. I mean, I don't know how you're going to get your spouse to agree to that. If they are open to that, then by all means, that can be done. If the house was purchased before the marriage, next question, if the house was purchased before the marriage and then refied after, and there were signatures by both parties, there's a very good chance that that house became marital property, or it could be argued that it was gifted to the marital estate. So yes, if there is a refi, if there is, someone is added to the title, something like that, then we're looking at a situation where property is going from non-marital to marital. Keep your questions coming as far as real estate, even though we're going on to the next slide. Let's say Eric and Tina have a joint account with $17K. Eric has investment accounts with $68K. In this situation, there's one option: split both accounts, or option 2, split the joint account, and then maybe the investment account is used as an offset for another property allocation. So, there might be an equity situation in the house or something, and we can say, okay, Eric is going to keep this investment account because Tina is going to stay in the house and she's going to get the equity. Retirement accounts. So Eric has a 401k worth $350K. Tina has a 403B worth $250K. Option 1, split both accounts. You have to use what's called a qualified domestic relations order in order to split both accounts. Those are special technical orders that have to be drafted and signed by the judge. There is an expense to those. They're generally, I'd say that it's about $1,000 that you're going to be spending, maybe a little bit more, in order to get each one of those drafted and signed by the judge. So that's something to keep in mind. So if you do decide to just do it that way, you're going to pay a little bit more in attorney's fees, but it could be a little simpler. You could do where Tina keeps her account and then you split Eric's, but split it in a way to equalize. So you're not splitting 50-50, but you're just splitting it to equalize. So there you'll save some money on attorney's fees. Or each is keeping their own, because sometimes people say, you know what, you keep your retirement account, I'll keep mine. You worked for yours, I worked for mine. We don't need to split those 50-50. In that case, you don't need any of these special quadros, as they call them, QDROs, qualified domestic relation orders. Let's talk about debts. In our situation, Eric has a Eric has a debt of $50K in student loans, Tina 25, and then credit card debt of $12K in Tina's name. So some various options. One thing to note is creditors don't care about your divorce. If you divorce and you are both on a credit card debt and you say in the divorce papers that, let's say that Tina and Eric have 20K in credit card debt to Chase. And the divorce says, well, Tina's going to be responsible for all of it. But then Tina fails to make the payments. Chase doesn't care. They're coming after both of Eric and Tina to get their money. And Eric can't say, well, wait a minute, there's a divorce here and Tina's supposed to take care of it. That's not your arrangement with the bank. Your arrangement with the bank is the original credit card application or offer that you signed saying that you would be responsible for it. So just keep that in mind. When you do split debts, generally not a good idea that the other side is going to be responsible for debts with your name on them. That is what will run you into credit issues down the road. So what we like to do is that you're going to be responsible for your own debts. But if we're deciding that debts are going to be split equitably, then you might get an offset from some other asset. So, for example, in this case, we could say each is going to take their own student loan and maybe Tina's going to take her credit card debt. That's not uncommon to do. People say, well, you got the education, so you're going to be able to use that down the road. So you're going to take on the student loan debt. Tina might say, yeah, I'll take the credit card debt because that was a lot of stuff that I bought that really was just for me. When these things go to court, it doesn't always shake out this way. A judge might look at Tina's debt and say, that's a marital debt. It was acquired during the marriage, so we're going to split it 50-50. Again, with the student loans, same thing. The judge might decide that's a marital debt. We're going to split it 50-50, regardless of who's getting the benefit of that debt. Other options are just kind of permutations of this where, Tina maybe's taking her credit card debt, but she's getting an offset somewhere else. And then finally, I just threw in there that the credit card debt was paid off by the house sale or refi. A lot of times that's what people do to handle debt is they say, okay, we're going to sell the house. Before we split anything of the house proceeds, we're going to pay off these various debts. Question from the previous slide, for retirement accounts that are pre-tax, how is that money valued as compared to other cash assets? That's a good question. That's why dividing the 401k makes a lot of sense because the valuation is somewhat technical. So rather than kind of speculate on what the value could be or using some sort of formula, that's where people will just say, well, let's just split it. And you send Fidelity a Quadro and they open up a 401k in your spouse's name and just move part of the balance there. And then you just know, okay, that was split fairly. The other way you have to do it is to get some sort of expert actuarial involved in order to decide what is the value of this retirement account. It's not uncommon that is how you figure out, because if you're using it to offset something else, you need to know what is the present day value of this 401k. And there's going to be a gray area. There's going to be tax implications. And oftentimes you start to get to a place where you're splitting hairs, and it's more expensive to split the hairs than it is the hair for the value of the hair itself. And that is where cases settle. It's like, let's not pay lawyers thousands of dollars to fight over hundreds of dollars, or even let's not pay lawyers thousands of dollars to fight over thousands of dollars. We're just giving our money away at that point. Next question is not a stupid question, and maybe something that I don't think I explicitly talked about. And that is, what is an uncontested divorce? Uncontested divorce is really it's not a legal term. It's more of a colloquial term that means a divorce that is agreed. We're agreeing on all the terms of the divorce. It's not whether or not, oh, well, my spouse agrees that we should get divorced as well, therefore I have an uncontested divorce. No, your divorce is going to be contested if you two do not agree on all of the things that I talked about before, all of the things that have to go into the marital settlement agreement. So uncontested, the way that we're using it here, means that you and your spouse have agreed on how you're going to divide property, debts, deal with income, etc. And then that just has to be memorialized, put down on paper in the proper formal way so that you're protected, they're protected, signed off, and you go to a judge and the judge signs off on it. An uncontested divorce should only be one court date. If you're doing anything more than one, maybe two in certain circumstances, like you just got to make sure you check a certain box that wasn't checked and the judge says, oh yeah, just give me that paperwork and come back. Your case should only be one or two court dates if it's uncontested. Does that make sense? If you have any questions on that process or whether or not your divorce is contested or uncontested, feel free to let me know. Is a 401k from before marriage required to be disclosed since it's not marital? The short answer is yes. When you do formal disclosures, you're disclosing everything, marital or non-marital. And that disclosure, the reason that you have to disclose non-marital property, one, is that the other party has a right to make an argument that it is actually marital and it's not non-marital. Sometimes there's a gray area. Two, the distribution of property and whether or not we're doing 50-50 or 60-40 or something like that, one of the factors that the judge looks at to decide whether or not this is a 50-50 case is the balance of non-marital property. So if one side has $1 million in non-marital property and the other side has zero, then you might see a split of marital property that's a little bit different. So yes, you need to disclose everything. There's a part of the divorce process called the financial affidavits, and that comes as the first step when you file a divorce case in a contested divorce. So you file a divorce case, you get the other side served, and then you have a certain amount of days to exchange financial affidavits. And those financial affidavits have to have everything on them. And if they don't, it can severely hurt your credibility. You can be sanctioned by the court. And you're certainly not looking at an uncontested divorce process, or even you're going to have a lot harder time having a more amicable divorce. So when you're doing an uncontested divorce, what we do, we generally advise our clients, listen, we want to be as transparent as possible here. One, because it's the ethical thing to do. But two, we can't really have a good faith settlement here if it comes out that you're hiding assets that should be disclosed. So generally speaking, you got to put your cards on the table if you're going to have an uncontested divorce, which is hard to do because I know that people earn money and they feel like, well, I shouldn't have to discuss this because X, Y, and Z. There is no, unfortunately, when you get married, they don't educate you on the divorce process. So a lot of this can be a surprise to people when they start going down this road. All right, so vehicles. Let's say that there is a 2021 Kia Telluride. Eric is on the note. And there's a 2012 Jeep Grand Cherokee that's been paid off. Again, creditors don't care about your divorce. So I would recommend, generally speaking, that Eric keeps the Telluride because he's on the note. If Tina keeps the Telluride and she doesn't make the payments on the note, guess whose credit is hurt? Eric's. That's like the big takeaway here is guess whose credit is hurt. If the payments are, think about it this way. If things don't go the way that they should, who's going to hurt for it? So if the payments aren't made, Eric is going to hurt for it. So Eric would make sense that he keeps the Telluride. Now there might have to be some balancing of value there, and there might have to be some balancing of value, and that would be put down on a balance sheet. And that would help the parties understand, okay, where does there need to be an offset for one thing or another? Question, what happens if they hide assets? For example, buying a car but putting someone else's name. If somebody is hiding assets, it depends on how much they're hiding, and to what level it makes sense to fight to expose them, the degree of value that's being lost. You do have, if you're in a sticky situation like that, you do have to make some tough decisions as to whether or not it makes sense to fight that. So, we look at every situation uniquely and decide whether or not we think it makes sense for you to go after the other side for hiding something. So there are mechanisms in the law to go after someone who's hiding assets, but they're not free. And so you need to decide whether the cost of those mechanisms, and when I say not free, I mean you're paying lawyers to utilize those mechanisms, whether or not the cost of those mechanisms is low enough or there's a big enough upside that it makes sense. And I'm taking into account the fact that if things are bad enough and there is money there, you may be able to get the judge to say your spouse has to pay your attorney's fees because you were hiding assets, etc. So that's really a situation where we look at it on a case-by-case basis. This call is, this slide has got a lot of info here, but I'm going to break it down as much as possible as far as how alimony works. So alimony it works on there's two different kind of factors, if you will. You figure out the amount, and the amount is a calculation of 1/3 of the breadwinner's net annual income minus 1/4 of the recipient's annual income. And then there's a kind of a little caveat there that says, well, the recipient cannot exceed 40% of the total of their net incomes. Don't try to figure this out right now. Sit down later and put pen to paper and to really understand it. And then as far as the duration of the alimony, we take a factor of the number of years that you have been married. So for example, if you've been married 9.5 years, you're going to have a factor of 0.4. So you're going to multiply 9.5 times 0.4, which will give you the duration of the alimony payments. So you got a couple options as far as negotiating alimony. You either follow the guidelines, you negotiate your own amounts, or you both say, we're not going to do maintenance. Couple questions that we have. What if the other side is splurging money so they don't give you what they have in their savings? Well, splurging money could be characterized as dissipation. Dissipation is a legal term that means that they're wasting money away, and the judge will order them to reimburse you for that money. So it depends on how much money they're splurging away. A lot of times this comes down to, like, if you don't take actions, then you're losing money. So if these things are happening, then, you're not going to always get, and usually you won't get all of the money back. So it really, don't rest on the fact that, oh, I'll probably get money here that they've been splurging. I'll probably get it back, so I can just kind of take my time. If this stuff is going on and you're going to get divorced, then it is silly not to start the divorce process as soon as possible. What happens to Social Security? Nothing happens to Social Security. Your Social Security isn't touched. It's not split. It's not touched. Nothing happens to it. Is it typical for maintenance to end if the payee gets remarried, moves in with someone? Yes. And that's something I should probably add to this slide. But there are terms for when maintenance is going to end. And the most common one is when they start living with someone. And there's I'm sorry about that. My phone is ringing. There's a technical term for that called continuing conjugal basis, and basically means they're not just a roommate, but they're living with them romantically. What happens to an employer provided life insurance policy? That's going to depend on the specific policy. So it is something that, you need to disclose, but the terms of that policy and what happens if there's a divorce, that's something that you got to look into the policy and probably talk to HR at your work about. And then child support. Well, what is the child support going to be? So for this one, I just threw up there the Google search that you should be doing in order to figure this out, and the link that you should be clicking on. Child support is based on three major factors: your income, your spouse's income, and the number of overnights that you each have with the children. You're not going to be able to change your income or your spouse's income very easily. Like if you're the type of person that says, well, I'm going to quit my job so I don't have to pay child support. That's not going to work. Like, it's going to be clear what happened, and a judge will often impute income to that person. Say, listen, you've been making $150,000 a year up until like just now when this divorce is going. You can make $150,000 a year, and we're going to calculate your child support based on you making $150,000 a year. So now you don't have a job and you have a child support payment based on $150K a year. Overnights, the amount of overnights that you have with the child is the number one thing that will affect it. So you having at least 40% of the overnights is going to drastically lower the amount of child support you pay or the amount of child support that you receive. That's the big takeaway here. It's 40% of overnights is kind of the magic number to really change the amount of child support that it's going to be at play. Now, that is not a silver bullet by any means. I've had judges say, I'm not going to give the dad the discount for the 40%, even though the law says that the judge should. It is technically a guideline. So you got to be careful with that. You could play the overnight game and try to get more overnights just to lower your child support for it to not work. There's very little guarantees. And when it comes to kids and child support, I would not want to, how can I say it? Gamble on that one or bank on that. Question: if the mom works part-time and the dad works full-time and he wants 50-50, can he get 50-50? The short answer is yes. There's nothing barring him from getting 50-50. The thing that the court is going to look at is what's in the best interest of the child or the children. If the dad who works full-time has been somewhat quote unquote absent in the life of the kids, or the mom really has a much stronger relationship with the kids, then unfortunately, and this, doesn't feel right inherently from one perspective, the mom is going to have an upper hand in that. And if it becomes a contested battle in court, the guardian ad litem, the person who's really going to make some big decisions or big recommendations for the judge, the guardian ad litem, that's a person who's appointed to interview you, the mom, the kids. Then, that person's going to look at, well, is it in the best interest of the children to start living with dad 50-50 or living with mom? And that's a really hard question to answer. And sometimes they might say, yeah, the dad is fully capable of taking care of these children, even though he's working full time. And these kids need their dad 50% of the time because he's a great role model. He hasn't had as close of a relationship with the children, but that's by no fault of his own. He was supporting the kids. And now that the parties are split, it's a different situation. So it can certainly happen. It's going to depend on, the 17 different factors that the court looks at to decide what's in the best interest. But just because she's part-time doesn't mean dad doesn't get 50-50. What if dad abandoned the kids, then cut them off financially and now wants to retract? Well, that's going to be looked at. I mean, there's the good and bad part about the standard, the legal standard being best interest of the children is it encompasses everything. Really, there's not a whole lot that the court's going to say, well, we're not going to look at that because it doesn't have to do with the best interest of the children. Anything that affects the children or may affect the children can be looked at. So dad cutting the kids off financially is going to be one of many factors that's looked into when deciding what's in the best interest of the children. Next question. What's the interplay of maintenance, payments, and child support? There is certainly an interplay. And if you look at the calculator, I believe maintenance is one of the variables that goes in there. It can get a little bit technical with the formula, so I'd have to revisit it. But I know that you do get some credit for maintenance. So if you're paying a ton of maintenance, your child support is going to get lower. So oftentimes we see situations where one party is going to pay maintenance for a few years or pay child support for a few years. The kids are going to age out of child support. And then maybe the maintenance is actually going another 5 years after that. And because the kids have aged out of child support, the maintenance payment actually goes up. But then there may be some sort of post-secondary school payment that's being made, some college type of payment that could affect maintenance as well. So there's definitely an interplay. All right. So that's the big stuff on the marital settlement side, marital settlement agreement. That's like the money side. The next side that we're going to talk about is the allocation judgment or the parenting plan. There's two big sections when you're talking about the parenting plan: significant decision-making and parenting time. You guys need an agreement on both of those. So what's significant decision-making? It's decisions in the areas of medical, education, religion, extracurricular. And the options are pretty straightforward. Either you have joint for all, sole for all, or you have kind of a mix and match approach. I'll tell you this. If you're trying to get an uncontested divorce, it's either going to be most likely joint for all. In certain situations, I've seen it where it's sole for all, where one party says, you know what? I don't really want to be involved. You always wanted the kids. I didn't want the kids. And they just kind of say, I'm taking a back seat. As someone who's being a father is like the number one most important thing to me in the world. I can't imagine doing that, but I don't judge here. I just help people navigate to their next step. So there are situations where people say, you can have all the decision making, and so be it. One thing to keep in mind is, we do hold a lot of import to these decisions, but a lot of times these decisions, the decision-making authority isn't as powerful as you think, or, it depends on the situation. But for example, medical decisions, we're generally just making the decision, doing the thing that our doctor has advised us to do. But, when it can come down to some really important stuff, the stuff that we don't even want to think about, then it might be incredibly important for you to have a say-so in it, because there might be a couple different ways to go. And you want to make sure that you have the authority in those moments to make that decision. Parenting time, the other big one, the other sticking point, the thing that can drive people up the wall and make them get super stressed out and not know how they can get past some disagreements, is parenting time. So what we need to figure out for parenting time is, what is our day-to-day schedule going to be? What's our holiday, summer, and vacation schedules going to be? What's our transportation logistics going to look like? So there is no standard schedule. I've seen schedules of all sorts. There's 50-50 schedules, but 50-50 could be in multiple different ways. There's every other weekend schedules. The 5-2-2-5 schedule is a somewhat popular 50-50 schedule. I would just, if you're trying to look for ideas and think through it, just Google something like common custody schedules, and you could probably get a good list and kind of open up your head to different scenarios that you could use. So that is kind of the high level overview of the things you have to agree on. Now, just so you have an idea and kind of can think through this is the process for what happens after you agree in an uncontested divorce. So this is just outlines how we go from having a signed agreement to getting divorced. And this looks like a ton of different steps. It's something that one of our paralegals does in an afternoon and just gets it all done and teed up. So in the perfect uncontested divorce, we have all the documents signed off on before we even file any sort of case. Because once you file the case, then certain timelines start ticking and deadlines and all this sorts of stuff. So you really don't want to start filing cases until you have a game plan as to why you're filing the case. Am I filing this case because we're about to finalize it? Or am I filing this case because we're about to duke it out in court and I need to get a judge so I can file a motion to get myself parenting time or something like that? So let's do a quick recap. Step 1, we're going to get an agreement on property and support issues. Step 2, get an agreement on parenting issues, or vice versa. It might make sense actually to figure out the kid stuff first and foremost. And then step 3 is we're going to do the paperwork and follow the court process to get this done. So let's talk about, and we just got a few more slides here. Let's talk about some tips and strategies to keep your case as uncontested as possible. Step 1 is to really look for agreement on the process and not the substance. If you and your spouse are going to do anything by agreement, the first thing you need to agree on is how you're getting divorced. Are you going to go to mediation? Mediation is a great way to pay someone to help you navigate some tricky waters or, a lot of different technical issues. If you believe that it's likely to get a little contentious, then I would consider going to mediation, because a mediator can kind of control the emotional temperature of things and help you walk through different scenarios. If you need a referral for a mediator, you're welcome to reach out to our firm and we can help you do that. We want to maintain emotional control. People hire lawyers most often when emotions have gotten out of hand and they can't agree on the process with their spouse, or they can't agree on one particular term. And it's really hard to solve problems with somebody that there's some emotional baggage there. So Take responsibility for for being in control of the emotions. Don't poke the bear. You really, this is hard, and I know that it's way easier said than done, but because you are divorcing, but you need to try to take your ego out of it as much as possible, to not poke the bear. Take responsibility for your communications and be a diplomat, be a hostage negotiator. Hostage negotiators don't come in there and start blaming the kidnapper and telling them they're doing things wrong. No, they come in there as the ultimate diplomat to be able to diffuse the situation. So you don't want to argue. Don't make you statements. Don't blame the other side, and don't expect the process to be fair or for you to get your fair share. That's not what the process really is about. And, we all know it. I don't need to say it, but life isn't fair. So a lot of the times what people do is they get caught up in, fighting over what is fair. And if you really look at the monetary value of what is fair, it's not worth the fight. So, and oftentimes they have that intertwined with, well, I don't want them to get this amount because they don't deserve it, because they wronged me in the marriage, or whatever the case may be. The divorce process is the worst place to get retribution, if you even are trying to get retribution. And honestly, I would hope that you can just, get your emotional a closure somewhere else, or somehow. If you try to get it through the divorce process, you are in trouble as far as keeping it uncontested. A couple other tips. Don't assume your spouse agrees on something until you've explicitly talked it through. I can't tell you how many times someone says, well, we've agreed on everything. And then it turns out that they haven't agreed on some of the most important things. When you're talking through things, assume things are not going to follow the perfect path. This is how lawyers think. They think about, well, what if it doesn't work out? What happens then? You got to think 2 or 3 steps down the line. So if your spouse agrees to refi, but they can't, then what's going to happen next? The real estate agent, the sale price, are we splitting the proceeds? Those sorts of things. And then the easier you make this on your spouse, the more likely they are to cooperate with it. Litigation is bad because it's unpredictable, it's expensive, it's slow, it's stressful. There are so many reasons to try to avoid litigation. Everyone's so fast to jump to the litigation process because they think that, oh, well, they're not negotiating quickly enough, or they're not coming back with, a counter. We want to go to court. I want this done. I want this done. I want this done. What happens is you end up in court, and that process is not as fast as you want it to be. But then you're under these kind of arbitrary deadlines with the judge. You're having to follow these rules that are inherently, anytime there's rules in a system, it becomes less efficient. So usually the litigation process doesn't end up in any better place for people. So that's a lot. And we're just almost at the end of the hour here. And we've talked about key areas where you need to agree for your divorce, the essentials of a parenting plan, and how to draft an agreement that protects yourself as things don't unfold the way you want them to be, and practical steps that you need to follow. So there are no one-size-fits-all agreements. This is really a case-by-case situation. And you have to put on your problem-solving cap as you work through each one of the issues in your particular divorce. If you feel like you're stuck, you feel like it might help to talk to somebody to get you unstuck, your reward for staying at the end of this webinar is that you get to decide whether or not you want to jump on a call with yours truly. I don't charge for these calls because honestly, I know that there's a chance that you may become a client of mine. So that's part of the process of having a business, is that I give away some of my time. I help people, and then they hire me and hire my firm to help them. So if that's something that you're interested in, you could take advantage of that right now by clicking on this link here. And that's it. So if you have any other questions, let me know. I do see one other question. What if mom's part-time? What if the mom as a babysitter, dad wants 50-50, only to pay less child support, but he wouldn't be taking care of the kids? So when it comes down to these really nuanced questions of, does it make, like, dad wants half of the time, but he's not going to be there with the kids half of the time. If you can't resolve that, if you can't figure out how to resolve that with your spouse and get to an agreement, then you have to look at, well, what's the next step? The next step in court is that you have another professional, a guardian ad litem, in your life, and they're interviewing you, interviewing your spouse, interviewing your kids, and telling a judge what they would recommend. So you need to empower yourself to try to figure out what is the solution, because otherwise you're going to be in the court process, and you may have to go to the court process. If you feel very strongly that the kids should be with their mother, with you, 50% of the, or more than 50% of the time, and your husband is not agreeing otherwise, and you're at loggerheads, then by all means, use the court process. But just be aware that it's unpredictable, it's expensive, and it's stressful. So maybe it's a situation where you could go to mediation and find a nuanced balance between what is what you want and what the father wants. There's no one size fits all here, and you have to keep looking for solutions if you want to find them. That's it for today, guys. Thank you so much for taking the time, and it's always a pleasure to try to help people through this process. I wish you the best of luck. For those of you that did schedule with me, I look forward to talking with you, and I'll talk to you soon. Take care.